There's a fight that has been going on in numerous courts, including the Supreme Court, for over 2 years now that can change our country overnight. It's been on the back channels for years, but some new buzz has been going around. The case is known as Brunson versus Alma S. Adams et al. And has the potential to significantly reshape the world landscape by addressing concerns about constitutional adherence and accountability. The case focuses on whether lawmakers can be held responsible for actions that may have violated their oaths to protect the Constitution by refusing to pause the certification of the 2020 election at the urging of over 154 members of Congress. More simply put, it's kind of like the Supreme Court deciding that our politicians have been criminally negligent for not doing their jobs. Moreover, Brunson is attempting to hold Supreme Court justices liable if they don't do their job by upholding the Constitution. It's really ingenious, and the Supreme Court could be between a rock and a hard place. Three brothers, Rayland, Loy, and Darren Brunson, are amazing. Like pit bulls on a slab of meat, they don't come up for air, filing case after case in multiple jurisdictions that media won't tell you about. There are two main cases and related cases that we are going to look at in this video. The first, case number 22-380, is known as Brunson versus Alma S. Adams and sues 388 federal officers in their official capacities. I should make the point here that all of these cases are being submitted pro se, which means that the brothers are exercising their rights as U.S. citizens to represent themselves in the court system, right up to the Supreme Court. This seems ridiculous to many, but the Brunson brothers have an excellent understanding of the law and procedures and still enjoy the lenience of a pro se litigant. They amended the case many times, which shows that at least some judges were willing to be helpful. The Brunsons made numerous amendments doing the dance required to succeed in a system that has become so complex that it's impossible to beat the system these days as pro se. But the system may have met its match in the Brunson brothers. The second is case number 23-1073 and is known as Brunson versus Sonia Sotomayor and as well Justice Elena Kagan and Ketanji Brown Jackson. If the Supreme Court rules in favor of the Brunsons, it could set a powerful precedent, reinforcing the importance of upholding constitutional duties for politicians and judges. Such a ruling could immediately restore faith in the system, bringing clarity to questions of governmental responsibility and ensuring that future actions remain aligned with the founding principles of the country. This could lead to widespread reforms and a renewed sense of integrity in public. The applicable filings and documents will be linked in the video description for your convenience. As always, share and like this video and subscribe to my channel for some of the most well-researched content on the internet regarding the future of our world. I've got a little store that I have linked in the description. And if you'd further like to support my channel, you can leave a tip under the Super Thanks button below the video. The reason I wanted to put this video out now is that I've been hearing a buzz on some activity happening with the Brunson case that could put an end to this madness very quickly. Have you ever heard of the Brunson brothers? The Brunson brothers, Darron, Loy, Rayland, and Gaynor Brunson, are a group of musicians from Utah who gained recognition for their talents in the trumpet and musical performances. Early in their lives, the brothers began developing their skills in music, focusing primarily on brass instruments, particularly the trumpet. They have performed on over 60 national TV shows, including The Tonight Show with Johnny Carson and the NBC Christmas in Washington show with President Reagan, so they were a pretty big deal. In addition to their careers as musicians, the Brunson brothers have a strong connection to faith. At an early age, they began to participate in missionary work in various locations around the world. The Brunson brothers' music career began to wind down in the late 1990s and early 2000s. Over time, they shifted their focus from music to other pursuits, including political activism and constitutional legal challenges. There are actually two different Brunson cases with overlapping details, which can make things a bit tricky. Brunson versus Alma S. Adams et al. This case was filed directly with the U.S. Supreme Court docket number 22, 380. This case was an appeal from a state-level court and was fast-tracked to the Supreme Court. The Supreme Court ultimately denied to hear the case in January 2023 and again on February 21, 2023. A separate Brunson case was filed against the same defendants. This case was filed in the Utah District Court and dismissed on February 2, 2023, for lack of standing. This case was then appealed to the U.S. Court of Appeals for the 10th Circuit, which entered its judgment on March 17, 2023, upholding the dismissal. This second case might be headed for the Supreme Court, but it follows a separate track from the case that was filed directly with the Supreme Court in October 2022. Brunson v. Sotomayor. Case 23-1073 was filed with the Utah District Court by Rayland Brunson in 2023 and was dismissed on August 11, 2023. It was appealed in the 10th Circuit under case number 23-4108 and was dismissed February 9, 2024. On March 29, 2024, a writ of certiorari was filed with the Supreme Court. This case was quite different, though. Brunson sued Justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson in their official capacities for voting to deny the February 21, 2023 petition for certiorari. The court once again denied to hear the case based on sovereign immunity, the very same doctrine that Democrats have vehemently fought against in the case of President Donald J. Trump. The order stated that this does not set precedent, which appears very contrived. Further, the justices also ruled that neither state nor federal courts have jurisdiction in the case. Justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson recused themselves this hearing, which wasn't required. On May 25, 2024, Lloyd Brunson did an interview definitively stating that the Brunson v. Adams case is not dead. During this interview Loy was announcing a petition campaign and gave two different websites where the petition could be signed. He said that his team was working on uploading the petitions, but 4 months later, and both sites say coming soon. Loy also announced a letter campaign for people to support the Rule 11 petition on LoyBrunson.com. The next thing he said was rather curious. Brunson said that a plaintiff gets 2 opportunities for conference, which is a private meeting where the justices of the U.S. Supreme Court gather to discuss cases and make decisions. He submitted the second request for conference in the summer when the justices were not in session. When it went online, it said distributed, not distributed for conference, which is the norm, and no conference date was issued. On Friday, August 19, 2024, President Donald Trump announced that he supported the petition. On the following Monday, the conference was denied and the justices were not even there. Were they trying to avoid an influx of letters, or did Donald Trump's support of the petition in some way cause somebody to deny the conference? During this interview, Loy was urging people to get on board and flood the Supreme Court, but all of that has stopped and no petitions are uploaded. Why did this campaign abruptly cease? This alone did not really seem like that much of a deal, but then I started to hear from multiple sources that NDAs or non-disclosure agreements are being signed related to the Brunson case. This is why I decided to do this video today. So you might ask, what else can be done related to this case? Well, our laws have become so enormous and convoluted that there are several doors left to open. The Brunsons aren't done. It seems that there is something known as the Supreme Court's shadow docket, which refers to emergency decisions or rulings that the court makes without full briefing, oral arguments, or detailed written opinions. These rulings are issued quickly and can have significant effects on laws or policies, but the court may not explain its reasoning thoroughly. The shadow docket includes emergency stays, injunctions, and other procedural rulings that are often handled with very little transparency. These decisions are public, but may lack the visibility of full decisions on the court's regular docket. Also, when the Supreme Court denies certiorari or refuses to hear a case, it generally doesn't provide an explanation for why it rejected the case. This practice is another secretive process because the public and litigants don't know the court's rationale for declining to hear certain cases. These denials are made public, but the lack of reasoning adds to the lack of transparency. It is often possible for a case to be sealed or handled with the ultimate confidentiality. This can happen at the request of the government or parties involved, but it is not common. These shadow docket cases are handled discreetly, but they will appear on the court's docket in some form at some time. The orders or rulings of the shadow docket cases are brief and procedural, and the decisions often appear in the form of unsigned opinions. The orders for both Brunson v. Adams and for Brunson v. Sotomayor were filed with the clerk unsigned. Some have said that the court has already heard the court and heard the cases. I don't know, but the case was denied immediately after Trump encouraged petitions, and the orders were recorded without signatures. I don't know that the official hearing has already been held. I think that a deal has possibly been negotiated to hear the case on an emergency basis on the shadow docket. I also think part of the deal could be a favorable ruling on Brunson versus Alma S. Adams, which would remove much of the deep state puppets from office, but I also think there are multiple strategies in play. The reports of NDAs or non-disclosure agreements might be signed in relation to a shadow docket cases for several reasons, often related to maintaining confidentiality due to the sensitive or urgent nature of the matters involved. If the case involves matters of national security, classified information, or sensitive government operations, an NDA ensures that those involved do not disclose information that could jeopardize security or ongoing investigations. In cases where an emergency application is filed, but parties reach a settlement, an NDA may be signed to keep the terms of the settlement confidential, especially if it involves high-profile or controversial issues. And courts might require NDAs to ensure that information about pending decisions, legal strategies, or internal deliberations is not leaked prematurely. So the reports of NDAs related to this case are plausible. So, such an important case in which 154 members of Congress called for an investigation of electoral fraud in 6 states has been shuffled around with procedural hurdles and apathy by the courts, including the highest court in the world. The Brunson brothers have been a thorn in the side of Democrats for years, and they aren't giving up, so keep your eyes on the Supreme Court, because you never know what the white hats are doing to pull out.